We have an urgent legislative development that every firearm owner across America must scrutinize, particularly those who value economic freedom and privacy in their sporting pursuits. This development carries the weight of precedent, specifically the precedent of California's most restrictive ammunition controls, now packaged for national application. H.R. 7166, introduced by Representative Bonnie Watson Coleman of New Jersey, seeks to federalize California's most controversial ammunition regulations. The bill's full title reveals its tripartite assault on lawful commerce, mandating face-to-face ammunition transactions, imposing federal licensing upon ammunition vendors, and establishing surveillance protocols for so-called bulk purchases. This is not theoretical. This is House Resolution 71-166, filed in the 119th Congress, and it represents the most significant federal ammunition restriction since the Gun Control Act of 1968. So, let us dissect precisely what this legislation mandates, examine how its California antecedents functioned in practice, explore the constitutional vulnerabilities in its architecture, and identify which provisions pose immediate threats to competitive shooters, rural residents, and collectors across the country. Allow me to provide comprehensive background on this proposal's statutory framework, because the text, though not yet publicly available, follows an established regulatory pattern that California has field-tested for nearly a decade. During 2016, California enacted Assembly Bill 1235, establishing the nation's first ammunition vendor licensing regime. Proposition 63, passed that same year, layered additional restrictions, including mandatory face-to-face transactions and point-of-sale background checks for ammunition acquisitions. I'll quote the practical effect, as the terminology carries weight. The California Department of Justice interprets ammunition vendor to include any entity selling more than 500 rounds in any 30-day period. That threshold captures not merely dedicated firearms retailers, but hardware stores, sporting goods outlets, and private individuals at gun shows. The on-bank experience in California proved economically catastrophic. Between 2017 and 2019, ammunition vendors declined by approximately 48% in the state. Competitive shooting events relocated to Nevada and Arizona. Olympic hopefuls established residency elsewhere. But here's the critical part. H.R. 7166 does not merely replicate California's framework, it expands it. The federal bill proposes to eliminate entirely the direct-to-consumer ammunition market that has operated lawfully since the founding era. No more online transactions. No more shipments to residential addresses. No more privacy in sporting purchases. The face-to-face mandate functions as geographic discrimination. Residents of rural Montana, where the nearest federally licensed dealer may sit 80 miles distant, face compliance burdens that Manhattan residents do not. The Supreme Court has previously recognized such disparities in New York State Rifle and Pistol Association v. Bruin, noting that constitutional rights must function for ordinary people in ordinary situations. Now, for those unfamiliar with federal legislative procedure, let me explain what happens behind the scenes. H.R. 7166 currently awaits committee assignment. Given its sponsor's seniority, Representative Watson Coleman has served in elected office since 1974, it will likely receive preferential placement on the House Judiciary Committee calendar. The bill's prospects depend entirely upon the composition of the 119th Congress. Currently, Republicans maintain narrow control of both chambers. This legislation, in its present form, lacks sufficient support for floor consideration. But this delay is different, and that's why it matters. The 2026 midterm elections stand 20 months distant. Historical patterns suggest first-term presidents face significant congressional losses. Should control shift, H.R. 7166 or its successor provisions could advance rapidly. By introducing this framework now, proponents establish legislative precedent. They create talking points. They normalize regulatory concepts that were fringe positions merely 5 years ago. That normalization carries serious consequences. Consider the bulk purchase reporting provision. The bill requires federal notification when individuals acquire ammunition quantities exceeding thresholds yet to be determined. 1 case, 10 cases. The statutory silence is deliberate. This functions as registry architecture. The Supreme Court in United States v. Haney and in earlier Commerce Clause jurisprudence has expressed skepticism about federal tracking of lawful goods acquisition. Yet, H.R. 7166 would construct precisely such a mechanism using bulk definitions that could capture competitive shooters consuming 1,000 rounds monthly in training. Think about that. A 3-gun competitor practicing weekly fires approximately 200 rounds per session. Monthly training exceeds the reporting threshold in most proposed regulatory frameworks. The athlete becomes a surveillance subject. This is not public safety. This is the construction of administrative capability for future confiscation. What happens if H.R. 7166 becomes law? First, the transition would not be instantaneous. The bill contains compliance periods for vendor licensing, likely 180 to 365 days. Existing inventory could transfer under grandfather provisions, though the text's absence makes this speculative. But the moment federal implementation completes, the following occurs. Online ammunition retailers, Midway USA, Lucky Gunner, Brownells, and hundreds of smaller operators must cease direct residential shipments. They must either establish physical presences in every state or abandon markets entirely. Economic analysis from the National Shooting Sports Foundation indicates this would eliminate approximately 12,000 jobs and $2.3 billion in annual commerce. More significantly, it would reduce ammunition availability in rural jurisdictions by an estimated 60%, as distributors concentrate inventory in population-dense regions where transaction volumes justify compliance costs. Now, here's the part that should enrage every American. The bill exempts law enforcement agencies, federal officers, and military components. Private security details protecting elected officials maintain their supply chains. Government elites retain efficiency while ordinary citizens face friction. This creates 2 classes of Americans, one with full Second Amendment rights and one with rights subjected to bureaucratic filtration. That is precisely the constitutional violation the founders drafted the Bill of Rights to prevent. This legislative pattern has persisted for decades. The federal assault weapons ban expired in 2004 after proving ineffective. California's ammunition restrictions enacted in 2016 have generated 15 separate federal court challenges. The Ninth Circuit has upheld them. Other circuits have not yet spoken. Someone who is 21 today was an infant when the 1994 ban passed. An entire generation has grown up witnessing the normalization of incremental restriction. That normalization is dangerous. February 2025 matters because H.R. 7166 is not isolated legislation. Representative Watson Coleman has announced her retirement after 50 years in public office. This bill represents her final legislative priority, the federalization of state-level restrictions she has long championed. The court could address this through constitutional interpretation. The doctrine established in Bruin and reinforced in Rahimi demands historical tradition for modern regulations. California's ammunition controls lack such tradition. No colonial statute regulated powder or ball acquisition. No Reconstruction-era jurisdiction tracked lawful purchases. February 2025 may reveal whether legislative persistence or constitutional principle prevails. I'll be here when it does. If this analysis illuminated the stakes, engage with this content, because this fight is far from over. Armed citizens built this nation, and armed citizens will preserve it. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.